Maria, a 28-year-old elementary school teacher, was grading papers at home when she received a phone call that would test her understanding of debt collection laws and teach her valuable lessons about phantom debt scams. The caller identified himself as Officer Rodriguez from Legal Processing Services and immediately began threatening her with arrest for an unpaid debt that she had never heard of before. Maria had always been careful with her finances and prided herself on paying her bills on time and maintaining good credit. She had student loans that she was paying responsibly, a small credit card balance that she managed carefully, and no history of defaulting on any financial obligations. Ms. Martinez, this is Officer Rodriguez calling about a legal matter that requires your immediate attention, the caller said with apparent authority and urgency. You have an outstanding debt of $2,847 from a payday loan that you took out in 2019, and failure to resolve this matter today will result in a warrant being issued for your arrest. Maria was confused and alarmed because she had never taken out a payday loan and couldn't understand how such a debt could exist. She tried to explain that there must be some mistake, but Officer Rodriguez became increasingly aggressive and threatening. Ma'am, arguing with me is not going to help your situation, Rodriguez continued with apparent legal authority and impatience. I have all your personal information right here, including your social security number and employment information. This debt has been through the court system, and you now face criminal charges for check fraud and theft by deception. Rodriguez claimed that Maria had written a bad check to a payday loan company and that the debt had grown from $300 to $2,847 due to fees, interest, and legal costs. He insisted that she needed to pay immediately to avoid being arrested at her workplace, which would be embarrassing and could cost her job as a teacher. Ms. Martinez, I'm trying to help you resolve this before it destroys your career, Rodriguez explained with apparent concern mixed with authority. If the sheriff's department serves this warrant at your school, it will become public record and could affect your teaching license. I can give you one opportunity to settle this debt today for $1,500. But you need to make payment within the next 2 hours. Maria felt panicked about the possibility of being arrested at school in front of her students and colleagues. As a teacher, she knew that any criminal charges could seriously impact her career and reputation, even if the charges were eventually dismissed or proven false. Rodriguez instructed Maria to purchase prepaid debit cards from a local store and call him back with the card numbers to process the payment immediately. He emphasized that this was the only way to stop the legal proceedings and prevent her arrest. Ma'am, prepaid cards are the only payment method that can process quickly enough to stop the warrant from being executed, Rodriguez explained with apparent procedural knowledge. Once you provide the card information, I can immediately update the court system and prevent the sheriff's department from taking action against you. Maria felt overwhelmed by the urgency and the potential consequences described by Rodriguez. Despite having no memory of ever taking out a payday loan, she was afraid that some mistake or identity theft might have created a legitimate debt that could destroy her career if not resolved immediately. Maria went to a nearby store and purchased $1,500 in prepaid debit cards as instructed. She called Rodriguez back and provided the card numbers, believing that she was protecting her career and resolving a serious legal matter that could have devastating consequences for her future. However, after completing the payment, Maria began to have doubts about the legitimacy of the situation. She decided to research debt collection laws and discovered that legitimate debt collectors are required to provide written validation of debts and cannot threaten arrest for civil debts. Maria also learned that law enforcement officers do not collect debts for private companies and that no one can be arrested for owing money on payday loans or credit cards unless criminal fraud is involved, which requires extensive investigation and court proceedings. Maria realized that she had been scammed by criminals who used aggressive tactics and false legal threats to frighten her into paying money for a debt that never existed. The officer Rodriguez was not a law enforcement officer and had no authority to make arrests or legal threats. Maria immediately contacted her local police department to report the fraud and learned that phantom debt scams targeting teachers and other public employees are common because scammers know that these professionals are particularly concerned about protecting their careers and reputations. The police explained that legitimate debt collection involves written notices, proper identification of creditors, and validation of debt amounts through official documentation. Real debt collectors cannot threaten arrest, demand immediate payment through prepaid cards, or claim to be law enforcement officers. Maria reported the scam to the Federal Trade Commission, her state's Attorney General office, and the Consumer Financial Protection Bureau. She learned that phantom debt scams often target people with good credit who are likely to be concerned about protecting their financial reputations. The authorities advised Maria to monitor her credit reports for any actual fraudulent accounts and to never provide payment for debts that couldn't be properly validated through written documentation from legitimate creditors. Maria learned that consumers have the right to request debt validation within 30 days of initial contact from debt collectors, and that legitimate collectors must provide detailed information about the original creditor, debt amount, and consumer rights before pursuing collection activities. The experience taught Maria to always demand written validation of any claimed debts and to never make payments based on threatening phone calls, regardless of how urgent or official the callers claim the situation to be. Maria now educates other teachers about debt collection fraud and emphasizes that legitimate debt collection follows established legal procedures that protect consumers' rights and never involves threats of arrest or demands for immediate payment through prepaid cards. Robert, a 45-year-old construction foreman, was dealing with financial stress from a recent injury when he received aggressive phone calls that would test his understanding of legitimate debt collection and teach him valuable lessons about debt collection harassment tactics. The calls came from National Recovery Solutions, claiming he owed $4,200 on a credit card debt that had been charged off and was now subject to legal action. Robert had indeed fallen behind on some credit card payments during a period when he was unable to work due to a back injury, and he knew that at least one of his credit cards had been closed due to missed payments. He was working with his creditors to establish payment plans, but was struggling to manage his finances while recovering from his injury. The caller, who identified himself as Mr. Thompson, was extremely aggressive and threatening from the very first call. He claimed that Robert's debt had been sold to their company and that they now had the legal authority to pursue immediate collection through wage garnishment, asset seizure, and court action. Mr. Johnson, you owe $4,200 on a Capital One credit card that was charged off in 2021, and we have the legal authority to collect this debt immediately, Thompson said with apparent legal knowledge and threatening authority. This debt has been through our legal department, and we're prepared to garnish your wages and place liens on your property if you don't resolve this matter today. Thompson claimed that Robert had only 24 hours to make a payment arrangement or face immediate legal consequences that would result in wage garnishment, bank account seizure, and additional legal fees that would increase the total debt significantly. Mr. Johnson, I'm authorized to offer you a one-time settlement opportunity of $2,500 if you can make payment today. Thompson continued with apparent negotiation authority and time pressure. If you don't take advantage of this settlement offer, the full amount plus legal fees will be automatically deducted from your paycheck starting next week. Robert was concerned because he did remember having a Capital One credit card that had gone into default, and the amount mentioned seemed consistent with what he might have owed when the account was closed. However, he was suspicious of the aggressive tactics and immediate threats being used by Thompson. I want to resolve this debt, but I need to verify the information and understand my payment options, Robert said, trying to get more details about the debt and the collection company's authority to pursue the aggressive actions they were threatening. Thompson became even more aggressive when Robert asked for verification, claiming that requesting debt validation was a delaying tactic that would result in immediate legal action. He insisted that Robert's only option was to make payment immediately or face the consequences of continued non-cooperation. Mr. Johnson, the time for requesting validation has expired, and this debt is now in our legal enforcement phase, Thompson claimed with apparent legal authority and procedural knowledge. You can either pay the settlement amount today or explain to your employer why your wages are being garnished for unpaid debt obligations. Thompson also threatened to contact Robert's employer and family members about the debt, claiming that they had the legal right to notify third parties about his financial obligations and failure to pay legitimate debts. Robert felt intimidated by the aggressive tactics, but was also suspicious about the legitimacy of the threats being made. he decided to research debt collection laws before making any payments or agreements with National Recovery Solutions. Robert discovered that legitimate debt collectors must provide written validation of debts within 5 days of initial contact and cannot threaten legal action unless they actually intend to pursue such action through proper legal channels. He also learned that debt collectors cannot threaten to contact employers or family members except under very specific circumstances. Robert requested written validation of the debt from National Recovery Solutions and was told that validation requests must be made within 30 days of initial contact, which had supposedly already expired. However, Robert learned that consumers can request debt validation at any time, regardless of when initial contact occurred. When Robert insisted on receiving written validation before making any payments, Thompson became verbally abusive and threatened immediate legal action if Robert didn't cooperate with their collection efforts immediately. Robert contacted his state's Attorney General office to report the aggressive tactics and learned that National Recovery Solutions was not a licensed debt collection agency in his state and had no legal authority to collect debts or make threats about legal action. Robert also discovered that the legitimate debt collectors working on his actual credit card accounts had already contacted him through proper written notices and were working with him on reasonable payment arrangements, unlike the aggressive tactics used by National Recovery Solutions. Robert realized that National Recovery Solutions was either collecting on a debt that didn't exist or had purchased invalid debt information and was using illegal collection tactics to frighten people into making payments without proper validation of the debt's legitimacy. Robert reported the illegal collection practices to the Consumer Financial Protection Bureau, the Federal Trade Commission, and his state's debt collection regulatory agency. The authorities confirmed that the tactics used by National Recovery Solutions violated multiple debt collection laws and consumer protection regulations. Robert learned that legitimate debt collectors must follow strict rules about communication timing, validation requirements, and legal threats, and that consumers have extensive rights that protect them from harassment and abuse during debt collection processes. The experience taught Robert to always demand written validation of debts before making any payments and to report aggressive or threatening collection tactics to appropriate regulatory agencies that can investigate and stop illegal collection practices. Robert now educates other workers about debt collection rights and emphasizes that legitimate debt collection involves respectful communication, proper validation procedures, and reasonable payment arrangements rather than threats and harassment tactics. Linda, a 52-year-old nurse, received threatening phone calls about medical debt that would test her knowledge of healthcare billing and teach her valuable lessons about medical debt collection scams. The callers claimed to represent medical collections associates and insisted that she owed $3,400 for emergency room treatment from 2 years earlier that had never been paid. Linda had indeed visited an emergency room 2 years earlier for severe abdominal pain that had turned out to be appendicitis requiring immediate surgery. Her health insurance had covered most of the expenses, and she had worked with the hospital's billing department to establish a payment plan for her remaining out-of-pocket costs, which she had paid off over 18 months. The caller, who identified herself as Ms. Davis, claimed that Linda had an outstanding balance for laboratory tests and radiology services that had not been covered by her insurance and had been referred to their collection agency for immediate payment. Ms. Thompson, you have an outstanding medical debt of $3,400 from Metro General Hospital for emergency services provided in March 2021, Davis said with apparent medical billing knowledge and collection authority. This debt has been in our system for 6 months, and the hospital has authorized us to pursue immediate collection action if payment is not received within 48 hours. Davis claimed that the debt was for specific medical services including CT scans, blood work, and specialist consultations that had been provided during Linda's emergency room visit but had been denied by her insurance company due to technicalities in her coverage. Ms. Thompson, medical debts can seriously damage your credit score and affect your ability to obtain healthcare financing in the future, Davis continued with apparent healthcare billing expertise and consequences knowledge. We're offering a one-time settlement opportunity of $2,000 if you can resolve this matter immediately. Linda was confused because she was certain that all her medical bills from the appendicitis treatment had been resolved through her payment plan with the hospital. However, She knew that medical billing could be complex and that sometimes insurance claims were processed incorrectly or delayed. "I thought I had paid off all my medical bills from that treatment," Linda explained to Davis. "Can you provide me with detailed information about exactly what services these charges are for and why my insurance didn't cover them?" Davis claimed that she couldn't provide detailed billing information over the phone due to HIPAA privacy regulations, but insisted that the debt was legitimate and required immediate payment to prevent it from being reported to credit bureaus and affecting Linda's credit score. "Ms. Thompson, due to privacy laws, I cannot discuss specific medical services over the phone, but I can tell you that this debt is valid and needs to be resolved immediately," Davis explained with apparent regulatory knowledge and privacy concerns. "If you don't make payment arrangements today, this debt will be reported to all 3 credit bureaus and will remain on your credit report for 7 years. Davis offered to accept payment through credit card or electronic bank transfer, emphasizing that immediate payment was necessary to prevent credit damage and additional collection fees that would increase the total amount owed. Linda felt concerned about potential credit damage, but was also suspicious about the lack of detailed information and the pressure for immediate payment. As a healthcare professional, she understood that legitimate medical billing involved detailed documentation and patient rights to review and dispute charges. Linda requested written validation of the medical debt, including detailed billing statements and explanation of benefits from her insurance company. Davis claimed that written validation would take several weeks to process and that Linda's credit would be damaged in the meantime if she didn't make immediate payment. Linda decided to contact Metro General Hospital directly to verify whether she had any outstanding balances from her emergency treatment. The hospital's billing department confirmed that all her charges had been paid in full and that they had not referred any debts to medical collections associates. Linda also contacted her insurance company to verify that all claims from her emergency treatment had been processed and paid according to her coverage. The insurance company confirmed that all legitimate charges had been covered appropriately and that there were no outstanding issues with her claims. Linda realized that medical collections associates was either attempting to collect on a debt that had already been paid or was fabricating medical debt information to frighten her into making unnecessary payments. Linda contacted medical collections associates to inform them that the debt had been verified as paid in full, but the company insisted that their records showed an outstanding balance and continued to demand payment despite her verification with the hospital and insurance company. Linda reported the fraudulent medical debt collection to the Consumer Financial Protection Bureau, her state's Attorney General office, and the hospital's compliance department. She learned that medical debt collection scams often target people who have had recent medical treatment because scammers assume that patients may be confused about complex billing processes. The authorities explained that legitimate medical debt collection involves detailed billing statements, coordination with healthcare providers, and proper validation of insurance claim processing before pursuing collection activities. Linda learned that consumers have the right to request itemized billing statements for all medical services and to work directly with healthcare providers to resolve billing disputes before debts are referred to collection agencies. The experience taught Linda to always verify medical debt claims directly with healthcare providers and insurance companies before making any payments to collection agencies claiming to represent medical facilities. Linda now educates other healthcare workers and patients about medical debt collection scams and emphasizes the importance of maintaining detailed records of medical payments and insurance claim processing to protect against fraudulent collection attempts. Carlos, a 35-year-old small business owner, was managing cash flow challenges for his landscaping company when he received aggressive calls that would test his understanding of business debt collection and teach him valuable lessons about commercial debt collection fraud. The calls came from Business Recovery Group, claiming his company owed $6,800 for equipment rental from the previous year. Carlos had indeed rented some equipment for several large landscaping projects the previous year, but he was certain that all rental fees had been paid according to the rental agreements. His business maintained detailed financial records, and he regularly reviewed all accounts payable to ensure that supplier payments were current. The caller, who identified himself as Mr. Jackson, claimed that Carlos's company had failed to pay for equipment rental extensions and damage fees that had been assessed after the equipment was returned. Jackson spoke with apparent knowledge of commercial lending and business debt collection procedures. Mr. Ramirez, your company owes $6,800 to Mountain Equipment Rental for unpaid rental fees and equipment damage charges from contracts signed in 2022. Jackson said with apparent business collection authority and detailed account knowledge. This debt has been referred to our Commercial Recovery Division, and we have the authority to pursue immediate collection action against your business assets. Jackson claimed that the debt included rental extensions that Carlos had authorized verbally, late return fees, and damage charges for equipment that had been returned in poor condition. He insisted that the original rental company had documented all charges properly and had the legal right to pursue collection. Mr. Ramirez, commercial debt collection is different from consumer debt collection, and we have much broader authority to collect business debts quickly. Jackson continued with apparent commercial collection expertise and legal knowledge. We can place liens on your business equipment, freeze your business bank accounts, and pursue judgment against your business assets if this debt is not resolved immediately. Jackson offered Carlos a settlement opportunity of $4,500 if payment could be made within 24 hours, claiming that this would save Carlos money on additional legal fees and collection costs that would be added if the debt went through formal legal proceedings. Carlos was concerned because he knew that business debt collection could indeed involve more aggressive tactics than consumer debt collection, and he was worried about potential disruption to his business operations if the claims were legitimate. I need to review my records and verify this debt with Mountain Equipment Rental before making any payment, Carlos explained to Jackson. My business keeps detailed records of all equipment rentals, and I want to make sure I understand exactly what charges you're claiming. Jackson became aggressive and threatening when Carlos requested verification, claiming that business debt collection didn't require the same validation procedures as consumer debt and that Carlos was risking immediate legal action by not cooperating with their collection efforts. Mr. Ramirez, this is not a consumer debt situation where you can delay payment by requesting validation. Jackson insisted with apparent legal authority and business collection procedures. Commercial debt collection allows us to pursue immediate recovery action, and your refusal to pay will result in liens being placed on your business equipment within 48 hours. Jackson also threatened to contact Carlos's business customers and suppliers about the unpaid debt, claiming that business debt collection allowed them to pursue third-party contacts to pressure business owners into paying legitimate commercial obligations. Carlos felt intimidated by the threats, but decided to contact Mountain Equipment Rental directly to verify whether his company had any outstanding balances or unpaid charges from the previous year's equipment rentals. Mountain Equipment Rental's accounting department confirmed that Carlos's company had paid all rental fees in full and that they had not referred any debts to Business Recovery Group. They also confirmed that all equipment had been returned in acceptable condition and that no damage charges had been assessed. Carlos realized that Business Recovery Group was either attempting to collect on fabricated charges or was fraudulently representing themselves as authorized collectors for Mountain Equipment Rental without any legitimate authority. Carlos contacted Business Recovery Group to inform them that the debt had been verified as non-existent with the original equipment rental company, but the company continued to insist that their records showed outstanding balances and threatened immediate legal action. Carlos reported the fraudulent business debt collection to the Better Business Bureau, his state's Attorney General Office, and the Federal Trade Commission. He learned that commercial debt collection scams often target small business owners who may be less familiar with business debt collection laws and procedures. The authorities explained that legitimate business debt collection still requires proper validation of debts and cannot involve threats of illegal actions such as contacting customers or placing unauthorized liens on business property. Carlos learned that business owners have rights in debt collection processes and should always verify commercial debt claims directly with original creditors before making any payments to collection agencies claiming to represent business suppliers. The experience taught Carlos to maintain detailed business financial records and to always verify debt collection claims through direct contact with original creditors before responding to aggressive collection demands from third-party agencies. Carlos now educates other small business owners about commercial debt collection fraud and emphasizes the importance of maintaining accurate financial records and verifying all debt collection claims through proper business channels. Jennifer, a 29-year-old graduate student, received threatening calls about student loan debt that would test her knowledge of educational financing and teach her valuable lessons about student loan collection scams. The callers claimed to represent federal student loan recovery and insisted that her student loans were in default and subject to immediate collection action. Jennifer was indeed carrying substantial student loan debt from her undergraduate and graduate studies, but she was current on all her loan payments through the federal student loan servicing system. She had been making regular payments for several years and had never missed a payment or received any notices about default or delinquency. The caller, who identified himself as Agent Williams, claimed that Jennifer's federal student loans had been transferred to their recovery agency due to payment processing errors that had caused her account to fall into default status without her knowledge. Ms. Anderson, your federal student loans totaling $47,000 have been classified as in default due to missed payments that were not properly credited to your account, Williams said with apparent federal loan system knowledge and processing authority. Unless you take immediate action to rehabilitate these loans, the Department of Education will begin wage garnishment and tax refund seizure within 30 days. Williams claimed that Jennifer's loan servicing company had failed to properly process several of her payments, causing her account to appear delinquent in the federal student loan database despite her making regular payments. Ms. Anderson, this is unfortunately a common problem with the federal student loan system, where payments are not always credited correctly to borrowers' accounts. Williams continued with apparent system knowledge and bureaucratic problems expertise. The good news is that we can rehabilitate your loans immediately and restore them to good standing if you make 3 consecutive rehabilitation payments of $850 each. Williams explained that the rehabilitation payments needed to be made through their specialized processing system to ensure that the payments were credited correctly and that Jennifer's default status was removed from her credit report and federal loan records. Jennifer was confused because she had been making regular student loan payments and had never received any notices about missed payments or default status from her official loan servicer. However, she was aware that student loan servicing could be complex and that administrative errors sometimes occurred in the federal loan system. I've been making my regular student loan payments every month, and I haven't received any notices about problems with my account, Jennifer explained to Williams. Can you provide me with specific information about which payments were supposedly missed and when my account went into default? Williams claimed that he couldn't provide detailed account information over the phone due to privacy regulations, but insisted that Jennifer's account was definitely in default status and required immediate rehabilitation to prevent wage garnishment and credit damage. Ms. Anderson, I understand your confusion, but the federal student loan system shows that your account is in default, and we need to act quickly to prevent serious consequences, Williams explained with apparent regulatory urgency and system authority. If you don't begin the rehabilitation process immediately, the Department of Education will begin automatic wage garnishment that will take 15% of your income until the full loan balance is paid. Williams offered to begin the rehabilitation process immediately if Jennifer could make the first rehabilitation payment through credit card or electronic bank transfer, emphasizing that delay would result in wage garnishment starting within days. Jennifer felt concerned about potential wage garnishment, but was also suspicious about the demand for immediate payment without proper account verification. As a graduate student, she understood that federal student loan programs had established procedures and consumer protections. Jennifer decided to contact her official federal student loan servicer directly to verify the status of her loans and confirm whether there were any problems with her account or payment processing. Her loan servicer confirmed that all her student loans were current and in good standing, with no missed payments or default status in the federal student loan database. They also confirmed that they had not transferred her account to any collection agency or rehabilitation program. Jennifer also logged into her official student loan account online and verified that all her payments had been processed correctly and that her account showed no delinquency or default status. Jennifer realized that federal student loan recovery was fraudulently claiming that her loans were in default and attempting to collect unnecessary rehabilitation payments from her. Jennifer contacted federal student loan recovery to inform them that her student loans were verified as current and in good standing. But the company continued to insist that their records showed default status and demanded immediate rehabilitation payments. Jennifer reported the fraudulent student loan collection to the Consumer Financial Protection Bureau, the Department of Education's fraud hotline, and her state's Attorney General office. She learned that student loan collection scams often target current students and recent graduates who may be unfamiliar with legitimate federal loan collection procedures. The authorities explained that legitimate federal student loan collection involves official notices from approved loan servicers and established rehabilitation programs administered through the Department of Education, not third-party collection agencies demanding immediate payments. Jennifer learned that borrowers can always verify the status of federal student loans through the official National Student Loan Data System and should never make payments to collection agencies claiming to represent federal loan programs without proper verification. The experience taught Jennifer to always verify student loan information through official federal loan servicers and to be suspicious of any collection agency claiming authority over federal student loan accounts. Jennifer now educates other students about student loan collection scams and emphasizes the importance of using only official federal student loan resources to manage educational debt and resolve any account issues. David, a 41-year-old sales manager, was dealing with divorce-related financial stress when he received calls about old debt that would test his knowledge of debt collection statutes and teach him valuable lessons about zombie debt scams. The calls came from Asset Recovery Partners, claiming he owed $5,200 on a credit card debt from 8 years earlier. David had indeed experienced financial difficulties during his divorce proceedings several years earlier, including some credit card accounts that had gone into default when he was unable to manage all his financial obligations while dealing with legal fees and temporary reduced income during the divorce process. The caller, who identified herself as Ms. Roberts, claimed that Asset Recovery Partners had purchased David's old credit card debt and now had the legal authority to collect the full amount plus additional fees and interest that had accumulated over the years. Mr. Williams, you owe $5,200 on a Chase credit card account that was charged off in 2015, and we have purchased this debt with full legal authority to collect the entire amount, Roberts said with apparent debt purchasing knowledge and collection authority. This debt has been accumulating interest and fees for 8 years, and we're prepared to pursue legal action if you don't resolve this matter immediately. Roberts claimed that the original debt of $2,100 had grown to $5,200 due to interest, late fees, and collection costs, and that David was legally obligated to pay the full amount regardless of how much time had passed since the original default. Mr. Williams, purchased debt never expires, and we have the same collection rights as the original creditor, Roberts continued with apparent debt law knowledge and legal authority. We can pursue wage garnishment, bank account seizure, and legal judgment against you for the full amount plus additional collection costs and attorney fees. Roberts offered David a settlement opportunity of $3,500 if he could make payment within 1 week, claiming that this would save him money on additional legal fees and court costs that would be added if the debt went through formal legal proceedings. David was concerned because he did remember having a Chase credit card that had gone into default during his divorce, and the time frame mentioned seemed consistent with his financial difficulties from that period. However, he was uncertain about whether the debt was still legally collectible after so many years. I want to understand my legal obligations regarding this debt, David explained to Roberts. Can you provide me with documentation showing that you own this debt and information about my rights regarding collection of old debts? Roberts became aggressive when David requested documentation, claiming that debt validation was unnecessary for purchased debts and that David was legally obligated to pay regardless of any paperwork or documentation requests. Mr. Williams, we don't need to provide validation for debts that we've purchased legitimately, Roberts insisted with apparent legal authority and purchased debt procedures. Your obligation to pay this debt is clear, and requesting validation is just a delay tactic that will result in additional legal fees being added to your balance. Roberts also threatened to contact David's employer about the debt and to pursue immediate legal action if he didn't make payment arrangements within 48 hours, claiming that old debts could be collected through the same aggressive tactics as recent debts. David felt intimidated by the threats, but decided to research debt collection laws and statutes of limitations before making any payments to asset recovery partners. David discovered that his state had a 4-year statute of limitations on credit card debt, which meant that the 8-year-old debt claimed by asset recovery partners was beyond the legal time limit for collection through court action. David also learned that debt collectors must provide written validation of debts within 5 days of initial contact and cannot threaten legal action on time-barred debts unless they actually intend to pursue such action through proper legal channels. David requested written validation of the debt from asset recovery partners and informed them that the debt appeared to be beyond the statute of limitations for legal collection in his state. Roberts continued to insist that the debt was collectible and threatened immediate legal action, but refused to provide any written documentation or evidence that asset recovery partners actually owned the debt or had authority to collect it. David contacted his state's attorney general office to report the illegal collection tactics and learned that asset recovery partners was attempting to collect on time-barred debt using threats that they could not legally carry out. David also discovered that zombie debt scams often target people during stressful life periods when they may be less likely to challenge collection claims or research their legal rights regarding old debts. David realized that asset recovery partners was either attempting to collect on debt that they didn't actually own or was using illegal tactics to collect time-barred debt that could no longer be pursued through legal action. David reported the illegal zombie debt collection to the Consumer Financial Protection Bureau, the Federal Trade Commission, and his state's debt collection regulatory agency. The authorities confirmed that the tactics used by asset recovery partners violated debt collection laws and statute of limitations protections. David learned that consumers are not obligated to pay time-barred debts and that debt collectors cannot threaten legal action on debts that are beyond the statute of limitations for collection in their state. The experience taught David to research statute of limitations laws for different types of debt and to demand proper validation before making any payments to collection agencies claiming to own old debts. David now educates others about zombie debt scams and emphasizes the importance of understanding statute of limitations protections and never making payments on old debts without proper legal verification of collection authority. Patricia, a 56-year-old administrative assistant, received calls about utility debt that would test her knowledge of utility billing and teach her valuable lessons about fake utility collection scams. The callers claimed to represent Utility Collections Network and insisted that she owed $1,800 for unpaid electric bills that would result in immediate service disconnection if not paid within hours. Patricia had been a reliable utility customer for over 20 years and had never had her electricity disconnected or fallen seriously behind on her utility payments. She occasionally received past due notices if she was a few days late with payments, but she always paid her bills and maintained good standing with her electric company. The caller, who identified himself as Mr. Davis, claimed that Patricia's electric account had been referred to their collection agency due to unpaid bills from the previous year that had somehow not been credited to her account properly. Ms. Johnson, your electric account shows an outstanding balance of $1,800 for unpaid service from 2022 that must be paid immediately to prevent disconnection of your service, Davis said with apparent utility billing knowledge and disconnection authority. Our records show that several payments you made were not credited properly to your account, causing your balance to accumulate without your knowledge. Davis claimed that the electric company had tried to contact Patricia about the unpaid balance through multiple notices, but that the notices had been sent to an old address and had not reached her. He insisted that immediate payment was required to prevent disconnection within 4 hours. Ms. Johnson, I'm calling to give you one final opportunity to resolve this matter before the disconnection order is executed. Davis continued with apparent utility procedure knowledge and time pressure. If payment is not received within 4 hours, a technician will be dispatched to disconnect your electric service, and reconnection will require a $300 service fee plus payment of the full outstanding balance. Davis offered to accept payment through prepaid debit cards or electronic bank transfer, emphasizing that immediate payment was necessary to prevent service disconnection and additional reconnection fees. Patricia was concerned about the possibility of losing her electric service, especially since she worked from home and depended on electricity for her job responsibilities. However, she was also suspicious about the demand for immediate payment through prepaid cards. "I need to verify this information with my electric company before making any payment," Patricia explained to Davis. "I receive regular electric bills and have never received any notices about unpaid balances or disconnection threats." Davis became aggressive when Patricia requested verification, claiming that the disconnection order had already been issued and that only immediate payment could prevent service termination. "Ms. Johnson, there's no time for verification because the disconnection crew is already scheduled to disconnect your service this afternoon," Davis insisted with apparent operational urgency and disconnection procedures. "If you don't make payment immediately, you'll be without electricity until you can pay the full balance plus reconnection fees." Davis also claimed that the electric company's customer service department would not be able to help because the account had been transferred to their collection agency and could only be resolved through payment to Utility Collections Network. Patricia decided to contact her electric company directly to verify whether there were any problems with her account or unpaid balances that could result in service disconnection. Her electric company's customer service department confirmed that her account was current and in good standing with no unpaid balances or pending disconnection orders. They also confirmed that they had not referred her account to any collection agency. Patricia also verified that her electric company used only specific authorized collection agencies and official disconnection procedures that involved multiple written notices and opportunities for customers to resolve billing disputes before service termination. Patricia realized that Utility Collections Network was fraudulently claiming authority to collect utility bills and threatening fake service disconnections to frighten customers into making unnecessary payments. Patricia contacted Utility Collections Network to inform them that her electric account was verified as current and in good standing. But the company continued to insist that their records showed unpaid balances and threatened immediate service disconnection. Patricia reported the fraudulent utility collection to her state's Public Utilities Commission, the Federal Trade Commission, and her electric company's fraud department. She learned that fake utility collection scams often target customers during summer and winter months when people are most concerned about maintaining electric service. The authorities explained that legitimate utility collection involves official notices from authorized utility companies and established procedures for addressing billing disputes before service disconnection occurs. Patricia learned that utility customers should always verify collection claims directly with their utility companies and should never make payments to collection agencies claiming to represent utility companies without proper verification of authority. The experience taught Patricia to be suspicious of any utility collection demands that require immediate payment through prepaid cards or threaten service disconnection without proper written notices and dispute resolution procedures. Patricia now educates other utility customers about fake utility collection scams and emphasizes the importance of verifying all utility billing issues directly with official utility company representatives rather than responding to threatening collection calls. Kevin, a 33-year-old IT specialist, received calls about court-ordered debt that would test his understanding of legal procedures and teach him valuable lessons about fake legal debt collection scams. The callers claimed to represent legal enforcement services and insisted that he had missed a court appearance for debt collection and now faced immediate arrest unless he resolved the matter within hours. Kevin had never been served with legal papers for any debt collection lawsuit and had never received any court notices requiring his appearance. He maintained good credit and paid his bills responsibly, so he was confused and alarmed by claims that he had legal proceedings pending against him. The caller, who identified himself as Attorney Martinez, claimed that Kevin had been properly served with legal papers for a debt collection lawsuit, but had failed to appear in court, resulting in a default judgment and bench warrant for his arrest. "Mr. Patterson, you failed to appear for your court date on September 15th regarding a debt collection case filed against you by Capital Financial Services," Martinez said with apparent legal authority and court procedure knowledge. "Because you didn't appear in court, the judge issued a default judgment against you for $8,400 and signed a bench warrant for your arrest for contempt of court." Martinez claimed that Kevin had been properly served with legal papers at his residence. but that he had ignored the court summons and failed to respond to the lawsuit within the required time period, resulting in automatic judgment against him. Mr. Patterson's failure to appear in court for debt collection proceedings is considered contempt of court, which is a criminal matter that results in immediate arrest. Martinez continued with apparent legal knowledge and criminal procedure authority. However, I can arrange for the bench warrant to be recalled if you can resolve the judgment amount immediately. Martinez offered Kevin an opportunity to avoid arrest by paying the judgment amount of $8,400 immediately, claiming that payment would satisfy the court order and result in the bench warrant being canceled before law enforcement executed the arrest warrant. Kevin was alarmed by the possibility of being arrested for something he had no knowledge of, but he was also suspicious about the demand for immediate payment without any official court documentation or proper legal procedures. I was never served with any legal papers and never received any court notices, Kevin explained to Martinez. I need to see official court documents before I can understand what this case is about or make any payments. Martinez became aggressive when Kevin requested documentation, claiming that the time for requesting information had expired when Kevin failed to appear in court and that his only option was immediate payment to avoid arrest. Mr. Patterson, you had your opportunity to request information when you were served with the lawsuit, but you chose to ignore the legal process. Martinez insisted with apparent legal procedure knowledge and consequences authority. Now that judgment has been entered against you, your only option is to pay the full amount immediately or face arrest for contempt of court. Martinez also threatened that Kevin would be arrested at his workplace if he didn't resolve the matter immediately, which would become public record and could affect his employment and professional reputation. Kevin felt intimidated by the threats, but decided to research court procedures and verify whether there were any actual legal proceedings involving his name before making any payments. Kevin contacted his county courthouse to search for any civil cases or judgments involving his name and discovered that no debt collection lawsuits had been filed against him and no bench warrants existed for his arrest. Kevin also learned that legitimate court proceedings involve proper service of legal papers, multiple opportunities for defendants to respond, and official court records that can be verified through public record searches. Kevin realized that legal enforcement services was fraudulently claiming that court proceedings existed and threatening fake arrest warrants to frighten him into making payments for non-existent legal judgments. Kevin contacted legal enforcement services to inform them that no court proceedings existed involving his name, but the company continued to insist that their records showed valid court judgments and threatened immediate arrest if payment wasn't made. Kevin reported the fraudulent legal debt collection to his state's Attorney General office, the Federal Trade Commission, and the courthouse clerk's office that handles debt collection cases. He learned that fake legal debt collection scams often target people who are unfamiliar with court procedures and may be frightened by threats of arrest or legal consequences. The authorities explained that legitimate debt collection lawsuits involve proper service of legal papers, established court procedures, and official court records that can be independently verified through public record searches. Kevin learned that consumers should always verify claimed court proceedings through direct contact with courthouse records departments and should never make payments based on threatened legal action without proper documentation and verification. The experience taught Kevin to demand official court documentation for any claimed legal proceedings and to verify all legal claims through independent research with appropriate court authorities. Kevin now educates others about fake legal debt collection scams and emphasizes that legitimate court proceedings involve proper documentation and established legal procedures that can be verified through official court records rather than threatening phone calls demanding immediate payment. Angela, a 39-year-old dental hygienist, received calls about tax debt that would test her knowledge of IRS procedures and teach her valuable lessons about fake tax debt collection scams. The callers claimed to represent IRS Collections Division and insisted that she owed $12,000 in back taxes that required immediate payment to avoid criminal prosecution and asset seizure. Angela had always filed her tax returns on time and worked with a professional tax preparer to ensure that her taxes were calculated correctly. She occasionally owed small amounts at tax time, but she always paid her taxes in full and had never received any notices from the IRS about unpaid balances or tax problems. The caller, who identified himself as Agent Thompson from the IRS Criminal Investigation Division, claimed that Angela had underreported her income for several years and now owed substantial back taxes plus penalties and interest that had accumulated over time. Ms. Rodriguez, our investigation has determined that you underreported your income by $40,000 over the past 3 years, resulting in unpaid taxes of $12,000 plus penalties and interest, Thompson said with apparent IRS authority and investigation knowledge. This is now a criminal matter that will result in immediate arrest unless you resolve the tax debt within 24 hours. Thompson claimed that Angela's tax returns had been flagged for investigation due to discrepancies between her reported income and her actual earnings, and that the IRS had completed an audit that determined she owed substantial additional taxes. Ms. Rodriguez, tax evasion is a federal crime that carries serious penalties including imprisonment and asset forfeiture. Thompson continued with apparent criminal law knowledge and federal authority. However, the IRS is willing to resolve this matter civilly if you can pay the full amount immediately and avoid criminal prosecution. Thompson offered Angela an opportunity to avoid criminal charges by paying the tax debt immediately through prepaid debit cards or wire transfer, claiming that immediate payment would prevent the case from being referred to federal prosecutors for criminal action. Angela was alarmed by the possibility of criminal prosecution for tax problems she was unaware of, but she was also suspicious about the demand for payment through prepaid cards and the threatening tone used by Thompson. I need to verify this information with my tax preparer and review my tax returns before making any payment, Angela explained to Thompson. I've always filed my taxes correctly and have never received any notices from the IRS about problems with my returns. Thompson became aggressive when Angela requested verification, claiming that the investigation was confidential and that she could not discuss the matter with anyone else without interfering with a federal criminal investigation. Ms. Rodriguez, this is a federal criminal investigation, and discussing it with third parties could result in additional charges for obstruction of justice, Thompson insisted with apparent federal investigation authority and criminal procedure knowledge. Your only option is to resolve this matter immediately by paying the tax debt in full. Thompson also threatened that Angela would be arrested at her workplace if she didn't make payment within hours, which would become public record and could result in her losing her professional dental hygiene license. Angela felt intimidated by the threats, but decided to research IRS procedures and contact the real IRS to verify whether there were any problems with her tax returns or any investigations involving her taxes. Angela called the official IRS phone number and spoke with a real IRS representative who confirmed that there were no problems with her tax returns, no unpaid tax balances, and no criminal investigations involving her tax filings. Angela also learned that the IRS never contacts taxpayers by phone without first sending written notices through the mail, and that real IRS agents never demand immediate payment through prepaid cards or threaten immediate arrest for tax matters. Angela realized that the IRS Criminal Investigation Division was actually criminals impersonating federal agents and threatening fake tax prosecutions to frighten her into making payments for non-existent tax debts. Angela contacted the IRS Criminal Investigation Division to inform them about the impersonation scam, but the real IRS confirmed that no legitimate agents had contacted her and that the calls were from criminals using fake IRS authority. Angela reported the IRS impersonation scam to the Treasury Inspector General for Tax Administration, the Federal Trade Commission, and local law enforcement. She learned that IRS impersonation scams are extremely common and often target people during tax season when taxpayers may be more concerned about tax compliance. The authorities explained that legitimate IRS communication involves written notices sent through the mail and established procedures for addressing tax problems that never involve threats of immediate arrest or demands for payment through prepaid cards. Angela learned that taxpayers should always verify any claimed IRS contact through the official IRS phone number and should never make payments to anyone claiming to represent the IRS without proper verification through official IRS channels. The experience taught Angela to be immediately suspicious of any phone calls claiming to be from the IRS and to always verify federal tax matters through direct contact with official IRS representatives. Angela now educates other taxpayers about IRS impersonation scams and emphasizes that the real IRS never makes threatening phone calls or demands immediate payment through unconventional methods like prepaid cards or wire transfers. Michael, a 27-year-old restaurant manager, received aggressive calls about auto loan debt that would test his knowledge of vehicle financing and teach him valuable lessons about repossession threat scams. The callers claimed to represent Auto Recovery Solutions and insisted that his car loan was in default and subject to immediate vehicle repossession unless he made emergency payments. Michael had indeed purchased a used car with financing 2 years earlier, but he had been making his monthly payments consistently and had never received any notices about missed payments or default status from his legitimate auto loan company. The caller, who identified herself as Ms. Wilson, claimed that Michael's auto loan had been transferred to their recovery division due to missed payments that had not been properly processed by his original lender, resulting in his account falling into default status. Mr. Garcia, your auto loan account shows 3 missed payments totaling $1,247 that have caused your loan to go into default status, Wilson said with apparent auto lending knowledge and repossession authority. Unless you bring your account current immediately, we will repossess your vehicle within 48 hours. Wilson claimed that the missed payments were due to processing errors by Michael's original lender that had caused his automatic payments to fail without proper notification, resulting in his account appearing delinquent in the auto lending system. Mr. Garcia, this is unfortunately a common problem with auto loan servicing, where automatic payments fail due to technical issues and borrowers don't receive proper notification until their accounts are already in default. Wilson continued with apparent system knowledge and processing problems expertise. However, we can prevent repossession if you can make the missed payments immediately plus a reinstatement fee of $300. Wilson explained that the total amount needed to prevent repossession was $1,547, which needed to be paid through wire transfer or prepaid debit cards to ensure that the payment was processed quickly enough to stop the repossession order. Michael was concerned about the possibility of losing his car, which he needed for transportation to work, but he was also suspicious because he had been making his auto loan payments regularly and had never received any notices about problems with his account. I've been making my car payments every month through automatic withdrawal, and I've never received any notices about missed payments, Michael explained to Wilson. I need to verify this information with my auto loan company before making any additional payments. Wilson became aggressive when Michael requested verification, claiming that the repossession order had already been issued and that only immediate payment could prevent his vehicle from being towed within hours. Mr. Garcia, the repossession crew is already scheduled to recover your vehicle tomorrow morning, and there's no time for verification, Wilson insisted with apparent repossession procedure knowledge and operational urgency. If you don't make payment immediately, you'll lose your car and will have to pay additional fees to get it back from the impound lot. Wilson also threatened that vehicle repossession would severely damage Michael's credit score and could affect his ability to obtain financing for housing or other major purchases in the future. Michael decided to contact his legitimate auto loan company directly to verify the status of his loan and confirm whether there were any problems with his payment processing or account standing. His auto loan company confirmed that his account was current and in good standing with no missed payments or default status. They also confirmed that his automatic payments had been processing correctly and that they had not referred his account to any collection or recovery agency. Michael also verified that his auto loan company used only specific authorized collection agencies and established procedures for addressing payment problems that involved multiple written notices before any repossession actions were considered. Michael realized that Auto Recovery Solutions was fraudulently claiming authority to repossess his vehicle and threatening fake repossession actions to frighten him into making unnecessary payments. Michael contacted Auto Recovery Solutions to inform them that his auto loan was verified as current and in good standing, but the company continued to insist that their records showed missed payments and threatened immediate vehicle repossession. Michael reported the fraudulent auto loan collection to the Consumer Financial Protection Bureau, his state's Attorney General office, and his auto loan company's fraud department. He learned that fake repossession threats often target auto loan borrowers who may be concerned about maintaining their vehicle transportation. The authorities explained that legitimate auto loan collection involves official notices from authorized lenders and established procedures for addressing payment problems before any repossession actions are pursued. Michael learned that auto loan borrowers should always verify collection claims directly with their legitimate loan companies and should never make payments to collection agencies claiming authority over auto loans without proper verification. The experience taught Michael to maintain detailed records of auto loan payments and to verify all collection claims through direct contact with official loan servicers before responding to threatening repossession demands. Michael now educates other auto loan borrowers about repossession threat scams and emphasizes the importance of verifying all auto loan collection claims through legitimate loan companies rather than responding to aggressive collection calls from unauthorized agencies. These stories demonstrate that debt collection fraud exploits people's fears about financial consequences, legal action, and damage to their credit or professional reputations by using aggressive tactics, false authority, and urgent deadlines to prevent victims from verifying claims or understanding their rights. Always demand written validation of any claimed debts, verify collection authority through original creditors, and never make payments based on threatening phone calls regardless of how urgent or official the callers claim the situation to be. Remember that legitimate debt collection follows established legal procedures that protect consumers' rights and never involves threats of arrest, demands for immediate payment through prepaid cards, or harassment tactics that violate federal and state debt collection laws. Know your rights under the Fair Debt Collection Practices Act and report any abusive or fraudulent collection practices to appropriate regulatory agencies that can investigate and stop illegal debt collection activities.